Hello, my name is Daniela Spajic and I'm a doctoral researcher at CITIB, the Center for IT and IP Law at the KU Leuven in Belgium, the Autonomous University of Barcelona in Spain, and the University of Bologna in Italy. My doctoral research is part of the Marie Curie ITM project called LAST-JD, and in the course of this project I conduct interdisciplinary research on the ethical and legal issues of eHealth in terms of the sharing of health-related data in the Internet of Healthcare. In particular, the doctoral research seeks to explore the sharing of patient data in the eHealth sector from the perspective of a possible moral duty of patients to share their health data. My thesis starts from the consideration that the improvement of healthcare services, research and public health relies on patient data, which is why one might raise the question concerning a potential moral duty or a moral responsibility of patients to share the data concerning their health. Such a responsibility, moreover, would then logically also have subsequent consequences concerning the further sharing or the further transferring of health data for other participants involved, such as with other healthcare providers or researchers who possibly transfer the data further to other organizations. In particular, the research seeks to answer the following central research question. How would a possible moral duty of patients to transfer health data for the benefit of healthcare improvement, research and public health in the eHealth sector sit within the existing confidentiality, privacy and data protection legislation? This central research question will be addressed in essentially 4 steps. An introductory chapter in which I set the context of the research will explore the different notions related to data sharing with regard to the existing privacy, data protection, confidentiality legislations in the context of eHealth. Then, in the second chapter, I explore the ethical question if a moral duty of patients to share data, to share health data with healthcare professionals and researchers for the improvement of healthcare research and public health in eHealth exists. And second, does a moral duty of patients have further consequences for other organizations to transfer health data with other entities in eHealth? As a third step, I will explore how and to what extent existing privacy, data protection and confidentiality legislations restrict possibilities of a moral duty of patients, citizens, healthcare providers and researchers or also other organizations for the improvement of healthcare research and public health in eHealth. And finally, I will provide my conclusions based on the previous analysis that I made while taking a normative approach. Now, let's dive a bit into the aspect of data sharing in eHealth. Under the term eHealth, I refer to any digital service in healthcare, research or public health. And in principle, data sharing or data transfers can take place on 3 different layers. On the first layer, the patient may share his data with care providers, for instance, in terms of his or her treatment, research and or public health. The second layer concerns the transfer of health data between patients or voluntary citizens and researchers, which typically takes place for the purpose of research or public health. The third and final layer may be associated with the reuse of data when care providers or researchers transfer the data that they have collected from the patients or citizens to other entities. Now, the combination of the individual stakeholders involved in patient data sharing may vary depending on factors such as the purpose for which the data processing activities are undertaken and the deployment of eHealth technologies that ease the transmission of data between the different actors. The 3 layers therefore attempt to outline as a first starting point the collaborative setting and the possibilities, and to show the possibilities to transmit the patient's data for the benefit of healthcare research and public health in general. When elaborating on a moral duty of patients to share health data, several ethical outlooks can suggest different approaches to explore such a moral duty. Traditionally, ethicists have been distinguishing amongst other things between deontology, utilitarianism, communitarianism, and ethics of care. In general terms, while deontological ethics is typically associated with an individual's duty, utilitarianism is society-centered, as it focuses on the outcome and the benefit for society. The communitarian approach focuses on the collective responsibility, and its elements orient themselves according to the public interest or the common good. Finally, ethics of care considers the individual in relation to others and their relationship to one another. As we have seen before, the data can be transferred or shared between different stakeholders, and a moral duty of patients could therefore have further impact on the transfer of data through other participants, such as physicians or researchers. This could either be the case directly as a duty in its own rights, for instance, based on one of the ethical outlooks that are available here, or indirectly derived from the patient's duty. From the legislative perspective, however, a corresponding legal duty of patients to share their health data does currently not exist, and the relevant European and national confidentiality, privacy and data protection legislation will be explored to identify how such a moral duty or responsibility may be impaired by the respective legislation, or possibly even supported. On the one hand, there's an obvious tension between a moral duty and confidentiality, privacy and data protection legislation. For instance, when we consider the potential danger of misuse or unintended disclosure, but also the obstacles that come with the anonymization of data. Furthermore, the legal framework that is relevant to the sharing of personal data and health data is quite fragmented within and across countries. On the other hand, various legal tools can be taken into consideration that potentially support a moral duty. From a legislative perspective, of particular importance are the General Data Protection Regulation as law and the recommendation of the Council of Europe on the protection of health-related data as soft law. The GDPR governs the processing of data concerning health, which covers also the transfer or the sharing of data, and the Council of Europe recommendation provides guidelines on the processing of health-related data, which explicitly refers to the exchange and sharing of health-related data by means of digital tools. So when elaborating on a moral duty, different legal bases become relevant, such as consent, scientific research, substantial public interest, or the compatibility clause. But there are also data subjects' rights which are of interest, such as the right to data portability, which has been said to be an important tool for individuals to share their data. Thank you very much for your attention and your interest.